Good evening to one and all. It gives me immense pleasure to welcome our today's guest for this session, where we have Mr. Sanjay K, Chadha, Senior Advocate, Supreme Court of India and Managing Partner, BSK Legal, India. Sir has vast knowledge and experience in the field of law and has won many awards in this respective field. Before we begin with this session, I would also like to express my heartfelt gratitude to all of the students who are sincerely committed to make this event a grand success. I welcome you, sir, for this session.
So, good afternoon, sir. And the first question that I would like to ask is, how, according to you, will arbitration change the future of Indian dispute resolution mechanism?
Well, arbitration and other alternative dispute resolutions, I feel they are very, very important because of many reasons. Those reasons are very important, starting from, these methods are of alternative dispute redressal are, very informal, first of all. Secondly, they are very, very convenient to all the parties. If you take it if you take it from both the sides, they are very convenient. Procedures are also, as all of us are well aware, that procedure, if we follow the procedure, that is also to be, it's quite soft. It is, you can mold it as per the need. Like in the cases of technical disputes, we find that whenever there is some expertise is required, it is good to have, dispute redressal through alternative dispute redressal resolutions. It reduces the burden on the courts, as we are all aware. Otherwise, you are well aware of, all of us are well aware. If I talk about in Indian context, we have a scarcity of judges. We have less judges in all the forums, be it from district level to the Supreme Court. We have, if you compare it population-wise, we have less judges. Then you have aspect of confidentiality that is also there. Speedy, that is the important thing. And primarily, if we see the new law, just within one and a half year, the entire process is to be, that is the broader limit, the bigger limit, though it has been very recently increased by 6 months, wherein the pleadings for completion of pleading 6 additional months were given. So as a whole, what I feel, it is certainly much, needed, especially in case of the commercial litigation. And that is how, and internationally, if we see, it is certainly a great thing to have. That is the reason in 16th August 1996, to be very precise, we adopted this new Arbitration Act, which has, in these 24 years have seen many ups and downs, as many people say. It has consolidated, amended, and made a, as you call it, comprehensive law as far as the arbitration is concerned. And uniform legal framework globally, if I may talk about. We have adopted, as you are aware, we have adopted the model law of international commercial acts, which was passed by General Assembly in 1985. The United Nations General Assembly had passed this, and we adopted it in our Act 1996. Based upon that model, we have taken the same model. So what I feel, that certainly arbitration, to be very precise, mediation, that's the one of the much sought for. I have seen many cases solving out by mediation. When the time will come about it, I will certainly speak about it. It's one of my favorite mode of ADR, alternative dispute redressal. And rather, I would say it is ADR is alternative dispute redressal. Yes, correct. I think it is appropriate dispute redressal. So that's what I feel, that future is this, and that is the reason we have seen. And the other, it's not a small thing that in one line or two I can summarize it. Institutional arbitration. If you go by institutional arbitration, you see it. Huge scope is there, and that is the reason that all across the world we have institutions who are trying to basically solve various arbitration, commercial arbitration internationally. So I feel there is a great scope as far as the arbitration and the other ADRs are concerned. Yes.
Okay. So thank you, sir, for your valuable response. Indeed, I think that the ADR is something that has to be taken into consideration in the coming future. And so the next question that I would like to ask you, sir, is how effective could arbitration or different mechanism of ADR be in case of labor and industrial disputes?
Oh, as far as the labor law is concerned, I would say both arbitration as well as mediation have played great role. Mediation primarily, if I may say. What is mediation? There is a difference. Mediation is where an independent, neutral person sits in between and gets the dispute resolved. Mediators are trained now, and it has become a, much, as I had already said, it is now more and more mediations are being done at all level. We have seen, especially as you have specifically asked about the mediation as far as the labor disputes. I think it is very, very important, and I am of the opinion that in case we go for mediation in cases of labor disputes, as we are seeing lot of such are happening in all the labor courts, and also at the level of high court also. We see that mediators are playing important role, where mutually agreed person will basically help both the parties, and both the parties are winner here. The beauty of mediation is this, that no one loses, no one with smile over their face. Basically resolved forever. That's what is, I feel, the mediation is. And I always, whenever I talk about, as I said in the beginning of the, affection with this particular field, certainly, and these processes, as I was reading it somewhere, these alternative dispute redressal processes, resolution processes, they are not new to, as far as the Indian system is concerned. You just see, even during the time of, ancient time, we used to rectify our disputes within the society, within the panchayats, and so on and so forth. So mediation is a very, very phenomenal thing. That is the reason you see that, the new Consumer Protection Act, a new chapter is added, Chapter 5 is added. That shows that how it is now each and every place where mediation we are adding. Now you see each district court has a mediation center. So High Court, Supreme Court has an extraordinary good mediation center. And we see that every day in the mediation center, we see that disputes are resolved at Supreme Court level. So mediation has really done wonders, I would say, in resolution of disputes. And day by day, the number of cases which are decided by the mediators are not decided, I mean, which are mutually agreed, I would say, and closed by the help of the trained mediators are increasing day by day. The graph is like this. That is one. And as far as more specific, as far as the labor laws are concerned, I feel with the help of trained mediators, because disputes are very, that not that big. And many of the disputes are, they can be resolved with the help of mediator. Mediation can be of great help. That's what is my opinion as far as the labor laws are concerned, as you have asked.
And the next question that I would like to ask is that what are your views on the new changes that the arbitration regime has undergone?
Mm-hmm.
So,
okay. Well, as far as the arbitration regime is concerned, and so many things have happened, I would say in the year 1996, when this act, this law, 16th August 1996, when this law came into force in India, though we were having a Arbitration Act, 1940 Act, and then 37 Act, was the election that have taken place both legislatively by the legislature and also by our own judiciary. Various, I would say, judgments have corrected propositions of arbitration. That is one thing. So both judicially as well as legislatively, there is a change and corrections have taken place, I may say so. 2015. Saying that now the arbitration is a time-bound phenomenon, as mentioned even in the Act. But earlier, those 6 months are given by this amendment. 6 months were given. It was somewhat criticized also that as to why these 6 months are given for completion of pleadings. But this particular time was awarded, given for the arbitration, primarily to complete the pleadings. Then 8th schedule was added. That is another very phenomenal thing where, setting up of qualifications of the arbitrator is there, which is also, if we talk about it, there are many people who criticize it, that why not the foreign arbitrators are allowed. There is a requirement that the arbitrator should be an Indian citizen. So those qualification aspects are also added. But certainly, as a whole, if you ask me, there are many positives have taken place. The law has grown a lot. As I mentioned in the beginning, corrections have taken place both judicially as well as by the legislature. So there are a lot of steps being taken under this. And, though I say that in 2019 amendments, there are certain aspects which are not taken up. There are certain recommendations which were missed, like model rule of procedure for the domestic arbitration. It was a recommendation. There is that is not incorporated. Similarly, emergency awards to be added in section 2, which is not added. So all these things. So, but we are on the path of growth, like amendment in the Advocate Act was recommended. And even I was listening to one of the very prominent judge of the Honorable Supreme Court, Justice Chandrachud was saying so, and Justice Nariman was talking about it, that it is, if you have to make India as hub of international arbitration, you need to have these amendments are to be required. We have to really work a little more. We have to, like arbitration, it was suggested that foreign advocate should be allowed. This was not accepted. Then, as I said, that as we always call it, that the lawyers within the country are opposing the entry of the foreign lawyers. But so that is what I think we are on the right track. Probably we are moving ahead, and a lot of rectification to answer your question very specifically. A lot of corrections have taken place, and law as such, we all know that law is never static. Law serves the land, and as it is being always a dynamic part, so it has to change, it has to see all the corrections as per the need. So I think we are on that track, and it is growing day by day. That's what I feel.
Thank you so much, sir, for your generous response. Absolutely, transition need to take place in dispute resolution. There is no doubt in it. So the next interesting question to you is, owing to the dire need for arbitration in the country, what are the factors we shall need to work?
Well, it is, I think, more or less I have already talked about it. What all we should do. First of all, one more thing is there, that as far as the domestic arbitration is concerned, if you talk about domestic arbitration, we have still we have to awaken our people. Still, a large number of people are not, following the arbitration path, or the alternative dispute resolutions are not being that popular. Even I appreciated the forum which you have created. The name is Madhyasthta. So that is the Hindi version of mediation. So I once again congratulate you for that. Not only this is a wonderful form of practice. I think more and more people are joining it. And we are on the path of growth. That's what I have to say in this.
Thank you very much for your in-depth answer on the particular topic. One more question that I would like to ask you is that, sir, does the lack of proper infrastructures and policies take India a step back in the international realm of arbitration practices?
It's a very good question, I must say. Certainly, it has an effect, the way things are improving also, I would say. So if the infrastructure is better, we will have good cases. Certainly, it has affected our, I would say, mission, wherein this arbitration you have specifically asked. I would be giving the answer in the whole context of ADR, because ADR overall in last 1 decade, I feel, has lot of importance is being given to it. So what I feel, certainly lack of infrastructure has hampered its growth. But now the way, as I just mentioned, that we have rectified, corrected our fundamental position of law as far as the arbitration is concerned, both legislatively by amendment and judicially by its judicial pronouncements, Supreme Court, High Courts, and number of judgments. In even 2020 during Corona Kal, we have seen various judgments coming, and new dimensions are being given by all these judgments. So that's what I feel. I'm very confident that the coming decade is decade of ADR. That's what I feel, and that is the reason when I talk to the young lawyers and young budding lawyers, I tell them, I rather try and guide them that please concentrate, think about it. ADR itself is a great field where all of you should concentrate, think over that. This is also one of the phenomenon field which is going to grow very, very fast I must tell you, the graph is absolutely, going up. It's not something every day. I'm using the term every day. Phenomenal growth is there in this field of ADR. And the best part is the administration, the government, the courts, all are plus for it. All are very, very positively asking rather working with this and only this endeavor, that there should be growth in this. That's what I feel.
Thank you so much, sir, for such valuable answer. Now the next question is, what are your views? Sorry, sir. The next question to you is, should there be a demarcation between judicial intervention in arbitral proceedings?
Well, again, this is a very good question, I must say. And what I feel, the demarcation is already existing. If you read the provisions, the law is quite clear, I feel. Law is very clear. It says that there should be a limited scope of judicial intervention. Minimum intervention is what is basically is in our various judgments. It is being very clearly stated. Over the year, the scope is rather limited. It is reduced. That's what I feel. And if you say the judicial intervention is very specifically provided in the law itself. In our 1996 law, you can begin with with section 12, section 13, section 14, section 34. Let us take it one by one. Section 12, these four are crucial answers to your question. I need not to give this answer. This answer comes from section 12. Section 12 very specifically provides the grounds on which you have to, grounds of challenge. That's what is section 12, I feel. And section 12 very specifically says that when there is a doubt about the independence and the integrity of the arbitrator, impartiality is the right word, I think. That is what section 12 says. You have right, you can challenge it. Section 12b says that ability to unable to devote sufficient time. If the arbitrator, you feel that he is unable to devote sufficient time and the matter will not be able to close within the given scheduled time, that is 12 months. If you have a sufficient reason, then you can very well go for a challenge. We have, schedule 5 is specifically added. What are the justiciable doubts? Justifiable doubts are there mentioned in that. And schedule 6 says very clearly, it provides that the format in which you have to disclose this information. Then these two schedules are very, very important. Section 12, very categorically, even in the section 12, it is mentioned that these schedule should be adhered, and on these schedules we have to basically challenge it. Then justifiable, there should be justifiable doubt about the independence, as I said, as well as if the judges or the arbitrator, honorable arbitrator, is disqualified as per the, he is not qualified to become a judge. All those things can be very well challenged. This is the phenomenon. Then if we come to section 13, what is the procedure we have to adopt for challenging the arbitration proceeding? No one can be judge in his own case. If you have a clear-cut document, that is what one saying is there, nemo judex in causa sua. No one can be a judge in his own case. So what is the answer to that? The moment this section very specifically provides a time frame within which, if there is a veracity to challenge this thing from the day of the knowledge of constitution of the tribunal, when you come to know that this person has become the arbitrator in so and so case, you have very well right to go and challenge the constitution of the tribunal within 15 days. This time frame is provided. So our law is very clear. I want to say this. You just see what is section 14. It says that it gives mandate. It mandates the conditions when arbitrator has to be terminated. Arbitration has to be terminated. And when in place of him, another arbitrator should be appointed. Very clearly provided in, I think, section 14. So we must see this. There is a very limited scope of judicial intervention. Otherwise, what will happen? Now, I'll tell you very clearly. Otherwise, if this kind of intervention is allowed, what will happen? First, you spend 1 year in the arbitration proceedings, get an award, the party, whichever in whose favor the award is, the other side will go and file a challenge it in the court of law, and then you just see a long fight will continue. So we are very cautious about the fact that every order has to be, appeal, etc. is there. There is a specific provision, but we have to be cautious. We have to see that which are the grounds. Section 34, please see that. That is very, very important. Section 34 very specifically says when you have to recourse to the court in cases of arbitral awards. So Section 34 very categorically mentioned in its part 2, I think, where there are few grounds. Let's say incapacity is one ground. The arbitral agreement is not valid. So they have very, very specifically mentioned the grounds. No proper notice is given. The opportunity to represent is not given. Then you can very well challenge it. Award is not in terms of the in terms of the reference. If the award is not in terms, we have referred A, you are giving the award on the terms of B. So such thing can be challenged. Other very important thing is if the arbitral, let's say, dispute for which we have gone to the arbitration is not arbitrable as per the terms of the agreement, you can very well challenge it. So judicial intervention is there, but very minimal. And that is one which is very, very much enumerated in the law book, in the act itself. It is very much provided. But the question which comes to my mind is, now further which I want to tell you in addition to this, that these are the points. Though that question is that our judicial system, our judiciary, by virtue of various judgments, have rather minimized it, have also, the process is reduced. Process means you cannot challenge each and every order. That is not possible. You have to remain in these framework which we talked, section 12, 13, 14, and 34. These are the very important, crucial sections. We cannot, all of you know about section 5. Section 5 very categorically mentions it forbids the judicial intervention. So the thumb rule is section 5. And these are, I would say, which are permitted. Section 9 is also important. Section 16 is also important. These sections are very relevant, no doubt about it. It is not that we are blindly with it, that if some illegal order is there, you can very well challenge the illegality. But as a matter of fact, the minimum judicial intervention is what provided in the Act, and that is what is, I feel, the judicial pronouncements have always adhered to it. That's what I feel.
Thank you very much, sir, for sharing your views regarding Section 12, 13, 14, and 34, read with Section 5 of the 1996 Act, which speaks about the demand.
Not read. I mean, Section 5 itself is a provision which very clearly says that the Section 5 forbids any judicial intervention. You read that section.
True, sir. And sir, what are your views on anti-arbitration injunction being antithetical to the arbitration regime of India?
Look, this is a very important question, and primarily those sections which we just mentioned in the question you had asked before, I think all those sections are very important. Here, I would like to begin with the one judgment of Calcutta High Court, very recent judgment. I think it was in August, this judgment came. Balasur alloy judgment. It's the judgment where the Calcutta High Court has very clearly said that Indian courts can grant arbitration injunction against the foreign award. It's a very interesting judgment. But let us come back to the root question with what is anti-arbitration injunction. So this judgment, you must see, Balasur alloy judgment, which was on 12th of August 2020, very recently during the Corona Kal, this order has come. Grant of anti-arbitration injunction is against the against the cardinal principle of what I feel is against the cardinal principle of arbitration. You have to appreciate, from the beginning, we are saying that minimum intervention is what is the mandate given in the Act. What is the mandate given by various judgments? But Section 5 is phenomenal to quote here, very important, that only, very limited judicial intervention should be there. Section 9 is also very important, where judicial intervention is permitted. Section 45 is very important, where the judicial intervention is allowed. I need not to go into the detail of these sections. If you want, I can mention a line about, but all of you know about it, Section 9, Section 45. And of course, the umbrella under which the broad principle comes, that is Section 5. Now, Supreme Court in its various judgments, if I may begin with some judgments like if I begin with the judgment of Chatterjee petrochemical judgment, then Ayaswamy judgment is there, then you have National Aluminum judgment is there. All this, the spirit of these judgments was that existence and validity of arbitration agreement, basically, if that is there, arbitration agreement is there, whether an anti-arbitral injunction be granted or not, what Supreme Court says is that there should be a minimal intervention, first of all. Civil courts are not the correct remedy These are the words, the gist of these judgments. If there is an existence of arbitration agreement, that is what we have to see. The intervention by the civil court is not the correct remedy. That is what Supreme Court says. But a judgment of Supreme Court, 7 judges bench judgment, wherein 6 judges out of the 7 rejected this contention, and they have very categorically mentioned that minimum intervention is allowed. They have rather gone into detail of this, and they have very categorically mentioned in their order that which are the circumstances under which the intervention is allowed. Similarly, I would like to quote one of Delhi High Court's judgment, which was on McDonald's versus Vikram Bakshi was the name. So whether the civil court's jurisdiction to grant anti-arbitral injunction was a question. The court has very categorically said that this exercise is allowed, but it should be exercised very rarely. It has to be exercised in a very, it is not that it becomes a regular phenomenon. No, it's a rare exercise. And only in exceptional circumstances, you will get this kind of order from the civil court. So civil court, minimum interference, rare exercise, exceptional circumstances. These are the 4 or 5 things which are very, very critical. And today the law of the land is SBP company versus Patel Engineering, 7 bench judges. And that is what is the law of the land. But that, what I feel after reading Balasore Alloy judgment of Calcutta High Court, they have relied on not only SPB company versus Patel Engineering, also they have touched Chatterjee Petrochem, these 2 judgments. And I think the need of the hour, which as per if you go through these judgments, I think more clarity is required from Supreme Court on this particular aspect. Specific, I would say, specifically, it is required that the Supreme Court should, because various high courts have different opinions. As I mentioned about that McDonald versus Bakshi case, where Vikram Bakshi case. So these cases are very, very relevant. So, but what I feel a specific judgment of Honorable Supreme Court would give rather. So we might need a 9 bench order for that. But I feel the law is very clear. Minimum intervention. Rarely this exercise should be done. Extraordinary circumstances are important. And the spirit of Section 5 we cannot leave. Section 16 we can't, like this. This is broadly what I feel as far as anti-arbitration injunction is concerned. But internationally, there are many things if we go into that, because that is what I said, Section 45. Indian courts can intervene, but only intervene in the foreign arbitrations, but only it is in extraordinary circumstances. Then only, those extraordinary circumstances can be what I discussed, that there is no jurisdiction, no proper notice, and so on and so forth.
Thank you so much, sir, for your exceptional views on anti-arbitration injunction. So So the next interesting question is, could you please throw some light upon having the right to appeal under arbitration procedure?
Yes, I have very clearly mentioned this while in the earlier part of our discussion, that section 34, what 34 says, that is very important. Certainly, as far as the appeal part is concerned, we have to go to section 37 then. What I feel, when there is a procedural irregularity, when there is a judicial jurisdictional error is there, procedural error is there, then, and there is a substantive question of law which is wrongly been followed by the arbitrator in his award, then we have to go to chapter 9, appeal. Chapter 9, section 37 that's what is important. It talks about section 34 is also very important. What are the, I have discussed that, where to recourse, which gives you the permission to recourse, power to recourse to the courts against the award, arbitral award, that is section 34. And 37 is which gives you right, which are the orders which are appealable. So very clearly it is enumerated in section 37. When section 9, all of us know, interim injunctions can be taken from there. When the court says no, or rather grants, so any party can go in section 9 to the court. Section 34, if you don't get the order or you get the order, any party can go to that order is very much appealable. Then we have 16.2, 16.3. When you have a doubt about the jurisdiction of the arbitral tribunal, you can very well go. Or section 16.3, which says that when you feel that the arbitral tribunal has exceeds its jurisdiction, then you can go. Section 17 is there, where there is a interim order. You can go against that or in favor of that, if you have not got it. So there is a sufficient provision provided in our own act as far as the appeals are concerned, and we can very well use these provisions. Section 37 is very, very important. Section 34 is there, which talks about 9, 16.1, 16.2, 17. These are the very important, I feel, sections as far as the appeal is concerned.
Thank you very much, sir, for sharing your views on the various aspects of the right to appeal. Now, sir, one thing that I would like to ask is, I would like to know your views regarding the shift in the paradigm of the justice delivery system regarding arbitration.
I think that is what we are discussing today. That is what we have seen. And the spirit, and that is what I said, the entire next, the coming years, next decade, I said, is the decade for ADR. Very clearly, I'm absolutely clear about it. The growth of ADR, which we have seen in this decade, is phenomenal. The correction in the law, I'm talking about the positive side of it. 2015 amendment, 2019 amendment. And there is a further proposed amendment is there as far as the arbitration law is concerned. Similarly, other ADRs, if we talk about, mediation is being one of the most sought field. All the courts without exception, cells. All the courts, they don't, not only they have the mediation cells, but these courts are giving importance. There is a specific amendment is made in CPC, wherein the judges are now asking, the mediation is increased. What I mean to say is that today, if you go and file a practical aspect, I'm talking, you go to the court, the judges are very happy referring the matters to mediation. That is one aspect. Second aspect is, when the Act came into effect, there is a separate chapter, chapter 5, which says that mediation is very important aspect. So they are talking about mediation. Everybody is talking about mediation. I have told you lot of positive aspects have taken. The arbitration law is corrected both legislatively by various amendments and judicially by various judgments. We have seen so many of them I discussed. They are next step in our progress. One or the other thing is happening. And the growth is phenomenal because our judges are really working very hard in this endeavor. They are passing orders which are taking us to only one track, that this is what is, only one thing can be concluded, that arbitration, mediation, conciliation, all the other mediums also, they are what is the future of this, the justice delivery system is going to adopt this. And we have seen in West that yes, it has given results. So I feel future is very bright.
Okay, thank you so much, sir, for giving your valuable views to the shift in the paradigm of the justice delivery system. Now, the next question to you is a very personal question that I would like to ask to you is, how far has India reached in the roadmap of institutional arbitration?
Oh, that is, I feel, is one of the cause of concern. But that doesn't mean that we are not moving ahead in institutional arbitration. We are on the path of progress in it. Even in Delhi, if I may talk, we have a lot of institutions have come up now. In Delhi High Court, we have one, and we have seen in Kailash one is there, one institution is there. I'm not promoting any of them, but we have seen Geneva, London. Overall, if I may mention the number, international arbitral institutions are there, over 1,200, which is not a small number. So, because of their positivity, lot of them are developing. Again, those positive things are that they have their set rules, they have their set time, they have the excellent administrative control. All those things are attracting specifically the commercial litigation, international commercial litigation, disputes resolution, not litigation. So positivity is what is attracting all these things. And what I feel, they have got their own list of arbitrators. They have got their own rules, regulations. So these institutions are really working very, very nicely, I feel. And but still, as far as the Indian part is concerned, we were expecting a lot of changes like this. They have given the eligibility of the arbitrator, as I mean, I think 8 or 9 people are eligible, but one clause of it is being criticized by many people. Why not we can have the international arbitrators? Why can't we allow international lawyers to come and perform in arbitration and take part in the arbitration, represent the parties in the arbitration? Why can't? So this is one question. I think we are on the path, but there is a little opposition, there is a little criticism of this effect. So I think which we will certainly soon we will win over that. But there are certain negativities also institutional, if I may say, institutional arbitration has, like, it is little a costly affair. Like if we talk about like going to Singapore for an arbitration, it's a costly affair. The fees are high. All the system is little, you know, if there are smaller disputes, you can't go to these institutions where only the bigger issues we can talk about. Similarly, you know, the rule thing, as I said, that their rules are, you know, whoso, if it is suiting you, then you try and go to these institutions. But certainly, again, I would say slowly, gradually, we are moving towards it, and growth path is also there. We are really moving quite a fast in this, and we have seen a lot of commercial litigation. Again, I'm saying litigation, commercial disputes have been resolved by these institutions. Certainly, I feel, it's my own opinion, that it also has a bright future ahead. That's all I can say.
Thank you so much, Sanjay sir, for gracing this session with your knowledge, experience, and guidance. I'm sure students will be greatly benefited from this interactive session. Next to place on my record, special thanks to our principal in charge of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, Dr. Bhagyashree Deshpande ma'am, for her constant support and guidance. A big thanks to the management team of our college, and a heartfelt thanks to all the students participating in today's session. Thank you, everyone.